Taps, coffee brews, we're like, here we go. I'm the broken baker, chat's coming in slow. Lawyers pace, jury sits, the room hums alive. Leaning forward, screens glowing, this is where we thrive. Stream from roll real, chat's the heartbeat, loud and clear. Trials come and go, but we stay near. Crimes up, crimes down, you're always here. Drops, lawyer jumps, tension spikes, we freeze frame, the jaw drop, chats and lower yikes. Not mocking the mess, just sharing the rush. Even silence feels like a crush. We read this stream from roll real, chats the heartbeat, loud and clear. Trials come and go, but we stay near. Crimes up, crimes down, you're always here. So grab your mug, don't be late, the baker's life will set it straight.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any you might be, and welcome to finally some normal content again, because it's been a rough couple of days, but we are back with a new emergency petition in the Kelsey Fitzsimmons trial. If you're new to it, it is, thank God it's Friday. If you're new to it, Kelsey Fitzsimmons is the cop who, during not a domestic, because it wasn't really a domestic, it was while the cops were there to apprehend her kid, give it to the father who had gotten an emergency restraining order against her. Was it because she was maybe threatening to self-delete, or was he afraid she was going to do him something? We read his story. To me, it seemed kind of like he was just hitting every word you need to hit to get a motion to go your way in Massachusetts, kind of like someone in New Jersey writing a piece of paper against Aiden that is specifically 100% set up so you will get at least an initial positive reaction from the court system. During this incident, somehow, and there are different stories about how, a weapon ends up in her hand. Does she go to try and delete? Is she jumping behind a door, getting it, and the cop think maybe? Different stories, but he puts some bullets into her. And then it's the time where it goes Massachusetts, because it went pear-shaped right from the start. She spent 53 days in prison. She is a cop, used to be a cop. She had just been cleared to return to the force. And there is a grand jury that nixes what the DA wants to indict her with. So she's indicted for aggravated assault, I believe it is. But in the Massachusetts statute, just brandishing is enough to fulfill that. So yes, she is guilty of that, because the second you pull it out. But there could be some mitigating factors we haven't heard. She is released on bond on her own recognizance with a GPS tracker, has to stay at her mom and dad's house, and have to do a SCRAM device test to prove she is not drinking, because the boyfriend claims that she had been very violent at a soiree with some friends 3 weeks before when she was drunk. So she gets a drug test or alcohol test device that she must use. They then return to court and ask to have the bail conditions modified because it causes her physical pain to do this SCRAM test. She still has broken ribs. She has bullet fragment lodged in her back. Her what's it called, officer, her bail officer says she's doing everything she can, everything to try and comply with this. But I have seen her try over and over again and collapsing in pain on the floor. But she is filling every single. There's nothing where she tries to sneak out of it. I can attest to that. The judge, in the most Massachusetts of all Massachusetts ways, screams at the parole officer. That's the name I was looking for. Screams at the parole officer, just cuts him off, and sends her back to prison because she's a danger to society. She could have stayed at home with the GPS tracker. Miles King, who is up for murder, who's an idiot, who's up for murder, had a GPS track on him. He left his house. Yeah, then you go back to prison. This woman was doing everything to try and comply with the rules, but it caused her physical harm to follow the rules. They didn't say we don't want her tested. They didn't say she won't comply. The parole officer said, I watched her on the floor in pain trying to comply with your order. And the judge said, well, F that, she's a danger to society now. It wouldn't be Massachusetts if it wasn't bad. I'm sorry to all my lovely fans in Boston, but this is absolutely insane. Thank you, Dizzy Grenade, for being a member for 17 months. I'm not that desperate. No, I'm not that desperate yet. It'll come there. Probation's officer. Sorry. Yeah, my brain is a little fried. I had a stream earlier where I might have gotten a little heated. Probation's officer. But no matter what, this judge seemed to don't give a flying hoot that she was complying with everything. And her probation's officer saying, I'm all for it. So she went straight back to prison. We're talking about a state where a kid threatened to shoot up a school, got a $2,500 fine, and was out on the street, I believe the same or maybe the next day. This lady who, yes, brandishing is technically aggravated assault in Massachusetts. She's probably going to get some conviction for that. I don't doubt that, because the law, kind of like the witness intimidation law, is written really stupidly. But why this treatment of her? That's the thing I don't get. That's what free Kelsey Fitzsimmons is different than Karen Reed, because it's a different crime, and this crime, according to the statute, yes, she most likely broke the law doing that. But I could also see if you had a human being as a judge would say, she was clearly distressed. Clearly. So let's give her an ankle monitor. Let's give her a year probation. And let's try not to overdo this. This judge said, hold my beer, and ran harder at this woman than Bev ran to the White Claws on a Friday afternoon. It's Massachusetts. You know how stupid it is. Two cops in a room, nobody can get one shot. The one who got shot is the one that got arrested. Make it make sense. Well, again, she got shot, according to him, because she was brandishing a firearm. Let me make it absolutely clear. Anyone who pulls out a pew-pew in front of an officer has a very, very high risk of getting new holes in them. Because he doesn't know what you're going to use it for. Even if you do this, he doesn't know if you're going to do that. So he doesn't wait. That's how he's trained. Put them down. It's a threat to you. But there's a lot of things you can ask about how they went ahead with everything. Why did they call the ex-husband to the house so he could pick up the baby? Makes no sense. There were 3 officers at the scene. 2 of them goes with her, but because the husband, who they called boyfriend, fiance, gets to the house, one of them goes down again. Why didn't they handcuff her and say, we are going to pick up your pew-pew for everyone's safety? Let's just give you a nice set of bracelets. Why wasn't any of that done? None of it was done. Which, to me, I watch all of these sovereign citizen idiots who gets traffic stopped all the time. One of the most used things is, if the cops need to search you or anything, search your car, they will handcuff you for everyone's safety. Not only the cops, also for yours. Because, again, American cops live in a world. That's how much time it takes for it to go absolutely pear-shaped. So normally, you'll just handcuff a suspect, especially if you're going for a pew-pew. Why do you let her go into a room to pick it up? And the story, either she's going for it or she's standing there getting things for the baby and then runs for the door and comes out with it. Her story, his story, the truth, somewhere in between. But there's a lot of things where you can say, that's really dumb. How did they do it that way? Again, all of this is absolutely hypothetical. If you see a gun, you take a shot. If she's waving a gun around, all of this goes out the window because you don't know you could talk her down. You see a gun, you take a shot. That's how it is. That's how a lot of people get shot, because a cop sees a gun, they fire. So that's the big problem in all of this. Having a pew-pew, it doesn't matter if you have it here or you have it here or whatever. He's trained to act on that. And that's why a lot of people get shot, because they're dumb and pulls out a gun. Pulling a gun is a very, very good way to end up 6 feet under. I don't understand why they didn't make sure she couldn't pull a gun on them, which could have been done super easy. Hey, Kelsey, you know the rules. We're going to pick up your firearm. Do you mind we just handcuff you? Do you mind standing here with Officer Tommy and tell me where your gun are? I'll go pick it up. Make sure it's safe. Okay, it's in that cupboard. I'm going to go grab it. Everything cleared, safe, nothing. I'm going to put it in a bag. I'm going to take it out with me. You're going to get it back. But we just have to finish this business. All of that could have de-escalated before it escalated to where they needed to put holes in her. And that's the big problem I have with all of this. Where were all the necessary step you take? Because even though it's your cop friend, you are acting on an order that she's absolutely cray-cray. Either threaten her fiance, either threaten her kid and herself. Why do you say, well, just walk around the house? Come on now. How bad could it be? You know she has a firearm. Her mom allegedly was in the house, according to the document I read in my last Kelsey Fitzsimmons trial. Yeah, that's why body cam should be something for every police department. And apparently they had body cams, but these officers didn't have them. Let's just say this is all the Massachusetts that we come to love. No, but I read it in her. What was the last thing I read? That was her husband's where he wanted to put a lien on her house so he could get child support. There was a story of what happened up till and after the incident, and her mom was at the house. That's also where I learned he was ordered to the house, and he went there with his sister. Why would you put a psychological stressor into it, like the fiance who's taking a 5-month-old away from you? Put him at the scene. Is that standard behavior? I can see a lot of things go bad when you do it that way. Amore of LSC, thank you for becoming a member. Ember. That bit with the lien was too much. I believe so, especially when he figured out that he would get compensation for her full salary for it 17 years. It made no sense how he figured it out, but hey, sadly that's how the rules are. But I don't think they ruled on that one yet. But let's get into it. This is to the Supreme Judicial Court for Suffolk County on appeal from lower court matter. Defendant's emergency petition for release from order revoking terms of release brought pursuant to GLC 211, paragraph 3. Miss Kelsey Fitzsimmons, the petitioner and North Andover police officer and former corrections officer, was on release out of Essex Superior Court McCarthy-Neyman on pretrial conditions under. Miss Fitzsimmons had come back to court on her own motion through counsel after she was able to blow into a SCRAM alcohol monitoring device deeply enough due to her sustaining a gunshot wound to her chest with an attendant collapsed lung, broken ribs, diaphragm, and liver damage, requiring 53 days in the hospital. Counsel expected a short hearing where the defense reported the difficulties and had an alternative method of alcohol testing put in place. Instead, a completely improper nightmare scenario ensued. Rather than utilizing a readily available common alternative method of alcohol testing, the court surrendered the petitioner back to jail without a legal basis or a request to do so from either the Commonwealth or probation, in violation of GLC 276, Section 58B. She berated and shut down the probation officer, cut off counsel, and walked off the bench while undersigned was arguing for his client. In writing, she accused the defense of manipulating the situation and repeatedly misstated the record. Ms. Fitzsimmons respectfully asked the single justice to review the full audio hearing provided herein, take note of all such instances, and vacate the trial court order. She requested that the single justice, 1. Address the bail determination de novo, consistent with the applicable case law referenced infra. Grant Ms. Fitzsimmons liberty with personal cognizance and stay away order under Section 57, no finding of dangerousness required, or Section 87, bail terms imposed with agreement of defendant of the bail statute, or other such non-incarcerative relief in the alternative if the single justice deemed 58A conditions necessary, and send the case back to the Essex Superior Court before a different judge for the reasons set forth below. You probably all have listened to the audio recordings. The audio recordings are absolutely horrendous. And a judge walking off the bench is, we didn't even see Bev do stupid stuff like that. I don't know what had gotten into that lawyer that day, but something was really, really weird in that entire hearing. I wonder how often this type of motion is successful. Depends on the judge who sees it, I think. That was angering and heartbreaking to hear. I hope the rule in her favor on this. Again, I'm not a lawyer, but when I listen to smart people, it sounds like it's very sketchy legal ground this is made on. The ruling by the judge is absolutely sketchy, especially because no one asked her to put her back in prison. Not the Commonwealth, not the defense, not nobody. But she just said, back to the pen. That's so weird. She was very off, yes. Yeah, I think she's going for Judge of the Year this year. The alcohol testing device ordered by the court requires petitioner to blow intensely into an attached tube several scheduled times per day. After attempting to use the device as required, Ms. Fitzsimmons, in good faith, returned promptly to court, McCarthy-Neyman, to report she could not use the device without great pain and dizziness for up to 4 hours, and aggravating the healing of her broken ribs. Pain and dizziness notwithstanding, she tried and immediately passed 8 out of 9 tests, and when she called the monitoring authority on the remaining incomplete test after increasing breathing difficulty, she was told they may issue a warrant. They did not. Between the physical pain and the anxiety of a warrant issuing, causing her to be arrested and taken to jail again despite her good faith attempts, Ms. Fitzsimmons, through counsel, returned to court right away of her own accord. Counsel, and that's another thing, they go back and say, hey, judge, she's really trying, but this is destructive to her health. Can we find a solution? And the judge says, go fuck yourself, go to prison. Again, had her probation officer said, you need to come in, you failed 5 tests, or you didn't complete 5 out of 10 tests, you need to come in, we need to have a talk about it, and then we can weigh up and say, okay, what the hell is this all about? And what? I don't know what Zach just sent me about I think it's some breathing exercises. But again, she goes back and says, hey, I really, really want to be compliant. Can you help me? She's not drugged back into court. She is the one who tells everyone, hey, come back to court. I have a problem. Nope. Go straight to prison. Counsel filed an emergency motion to vacate the SCRAM requirement in favor of an alternative testing method, urine testing or a bracelet that detects alcohol through sweat or the like. The defense intended to ask the court and the probation for help, a reasonable accommodation with an alternative testing method, and instead was greeted with hostility, interruptions, obtuse posturing, presumptive skepticism, willful blindness as to the availability of other methods of testing, and grossly injudicious behavior, culminating in the court walking off the bench during the middle of argument of undersigned. See recording of full hearing filed herewith on flash drive as Exhibit 1. At the hearing, the Assistant Chief Probation Officer tested that he witnessed that Ms. Fitzsimmons could not take the test without severe pain and discomfort, and that he was not seeking to surrender her or assert that she was in non-compliance. The defense also provided the court with the confirming email from the ACPO. That's just and 2 affidavits from petitioner and her mother detailing her struggles. That's also just exhibits. Despite there being no surrender request, and despite the petitioner returning promptly and in good faith seeking a readily available alternative testing method, the court sua sponte denied the request for an alternative method and revoked her terms of release. The judge sent the serious injured police officer and former corrections officer to jail for 180 days as a danger to the community because she couldn't blow into a breath testing device intensely enough without causing pain and dizziness and aggravating her broken ribs. The court ignored the increased risk inherent in incarcerating a police officer and former corrections officer. The defense learned on September 28 that Ms. Fitzsimmons has in fact been targeted at the Chicopee Women's Correctional Center when at 9:15 on September 24th, a biological male identifying as a female threatened petitioner, saying in her presence, "I found out something about that B word," and later directly to Ms. Fitzsimmons. While walking to his cell, he began pointing and screaming at inmate Fitzsimmons, who was currently on the rec deck, and stated, "You PC biatch, you best check out who you're effing with. See Hampton Sheriff Department incident report filed herewith as Exhibit 6. The fact is that petitioner will continue to be targeted due to her profession and is at enhanced risk of harm 24 hours a day. There is no legal basis to hold her in prison as a pretrial detainee, especially given her law enforcement history. She is under enhanced risk of harm and even death and should be released forthwith." What's up, all? Then again, don't tell me. Hey, Inspire. Nothing's up. We're just reading a petition. No, it's just chat. Talking to chat. Yeah, it is very dangerous for people like her in prison. We're always saying, the diddlers will be taken care of in prison. So will police officers. Especially if you have probably shouldn't get into that. Especially if you have someone who has a different biology identifying as something else. Kelsey Fitzsimmons is a small woman. She's a small woman with medical problems. Even a medium-sized male can make a lot of damage to a person like her. I hope they really look at this one. In contrast, she was released pre-trial. Nope, sorry. Yeah, the case is compromised of only one sole indictment for assault by means of a dangerous weapon, a 5-year maximum felony for which she is eligible under the guidelines for a probationary sentence. On a theoretical plea, she would be a good candidate for continuance without a finding. Ms. Fitzsimmons will not plead or admit to this charge and has always asserted that she did not assault anyone with her firearm, but rather engaged in only a half-hearted attempt to self-harm. Putting the pew-pew to her head, the hypothetical disposition is noted only to underscore how the statutory factor seriousness of the offense impacts what a proper bail determination should be in the circumstances. So most likely, if she is convicted of this, and again, assault by dangerous weapon, it is enough to brand this in Massachusetts. You don't have to do anything. Pulling it out as I read the statute is enough. But even if she's convicted of this, there's a high likelihood that she was just going to get probation. So why is the judge like this? In contrast, she was released pre-trial only under a plethora of 58A conditions, more fitting for a career violent offender looking at years in prison, and only after substantial delay by the court micromanaging the release plan while she remained incarcerated. The records demonstrate that alcohol was not part of the incident in any way, and that the putative victim is in no danger from Ms. Fitzsimmons. See public statement of petitioner filed herewith as example 7. The undisputed fact of the case is that Ms. Fitzsimmons, approximately 5'3" and 110 pounds, was pew-pewed in the chest by a colleague on the North Andover Police Department who fired a 9mm projectile into her body while serving a 209A restraining order obtained ex parte by her fiancé. The order required Ms. Fitzsimmons to surrender her 5-month-old child to the fiancé and surrender her pew-pew to the police. In the space of 30 seconds, Ms. Fitzsimmons, upset by the events taking place, realized she had been betrayed by her fiancé, who had filed a false and self-serving affidavit after disappearing for 3 days. She lost her baby without ever having a say in the matter, and lost her job due to the nature of the order and the surrender of her firearms. Ms. Fitzsimmons was diagnosed with postpartum depression several months earlier, in March of 2025, and was on leave from the department while she raised her baby and convalescent. She had had her firearm license restored and had just been cleared to return to work when the restraining order was obtained behind her back, and it was served on her by her colleagues on the NAPD who were taking her baby from her. Miss Fitzsimmons, being distressed due to the surprise restraining order and the bombshell just dropped on her, raised her pew-pew to the side of her head in a half-hearted attempt to inflict self-harm. She put the pew-pew to her head, and she was shot in the chest by Officer Patrick Noonan. Code of Massachusetts Regulation 550 CMR provides that an officer may not use deadly force against a person who possesses only a danger to themselves. I stand corrected. I thought any waving of a gun would be a legitimate ground for firing. I know it is in some states. So when will we find out the judge is a relative of the fiance? It wouldn't surprise me. At what point does Kelsey's physical health and necessary medical treatment take priority legally? She's pre-trial. She has not been found guilty. She's not awarded to the state. This is maddening. This is actually why they are filing this emergency petition to try and get a judge higher up in the system to grant them a release, because we all heard what happened that day in court. That judge was way out of here. It seemed personal. And I don't know why. I don't know the judge. No one really have found anything on her, if you can say it that way. Maybe because there's been so much commotion going on right now in that area of the YouTubes, to see if this judge has any history of being a douche canoe or what the hell is going on. But it seemed very personal to me when she was sitting there. She acted vindictive, and yes, I hope that the Supreme Court says, no, we're going to change the judge, because this one clearly lost her marbles. She'd be better off in a psych ward, regular bed. I wouldn't be sure of that, because in a psych ward, there's also other inmates, and they are not always the funniest people to be around. Hey, sweet Caroline. Will the SJC watch the recording of the video? We don't know. We know it's attached to this motion as Exhibit 1. So they can do it if they want to do it. Let's hope they do it, because that makes it kind of clear that something is afoot. Reminds me of that movie Burial Ground, Nights of Terror, where a relatively grown-up son keeps breastfeeding in the many scenes and later turns into a zombie and eats his mama. I don't know why I pulled that up without reading it. I have to give you the Brandon treatment from now on, Fedorowski. Welcome back, anime. Massachusetts has a long history of prosecutorial abuse. Their right to due process really doesn't exist. No, and this is why we need to get back on the ship, everyone. This is another example why we need to be back on the same ship. You know what I'm talking about. The judge acted like she only heard she doesn't want to get a knock on the door. Yes, she didn't listen to anyone, and her screaming at the probation officer and cutting him off like he's part of the plot. That was weird. Where the hell did I go to? Oh, I need to go back to footnote 5. Noonan claimed Miss Fitzsimmons pointed the pew-pew at him and tried to pew him, which is vehemently denied by the petitioner. Initially, based on Noonan's accusation, petitioner was charged with assault with intent to unalive in violation of GLC 265, second 18B, along with 2 counts of assault by means of a dangerous weapon in violation of GLC 265, 15BB. The allegation of intent to murder, along with the extra assault by means of charge, was rejected by a grand jury. As confirmed in open court by the prosecutor, 1 count of assault with intent to murder and 1 count of assault by means of dangerous weapon charges was brought for consideration, and only a sole charge of assault by means was true billed by the grand jury. The prosecution was unable to establish probable cause that there was an intent to murder in its most favorable and scrutiny-free forum, and came away with probable cause for the mens rea of only assault. The Massachusetts sentencing guidelines provided for a probationary sentence in Ms. Fitzsimmons' circumstances in the little no record category for the 1 count in this case for this maximum 5-year felony with concurrent district court jurisdiction. Unless the court acts here, she will have to endure pretrial incarceration on a case where if she pleads guilty, which she will not do, she will almost inevitably get probation. This sole charge does not warrant detention or any 58A finding. See infra. Where the hell was the sub? There. There was no intent to unalive, no malice, no evil intent, only self-deletion, desperation, engendered by postpartum. A scenario that cannot justify a judicial declaration that Miss Fitzsimmons, a police officer and former corrections officer, must be locked up with no possible alternative as a danger to society and to the armed and trained police officer who almost unalived her. The trial court's order is as heartless as it's legally baseless and must be reversed. Requiring that bail be revoked only after finding that there is no combination of conditions that would allow the defendant's release furthers the bail statute's purpose of establishing the right of the accused in its most circumstances to be admitted to bail. Paquette v. Commonwealth. Commonwealth v. Fanelli. Judge J. at Juvenile v. Commonwealth. This case firmly fits in the broad category of circumstances where the accused, a candidate for probation and/or a continuance without a finding, should be admitted to bail. Single justice jurisdiction for bail issues. The proper means for review of errors attend to a trial court bail revocation is through a petition to the single justice, invoking the court's inherent authority to correct errors and abuse in inferior courts, as codified in GLC 211 Sec 3, see Commonwealth v. Pagan, Commonwealth v. Delaney, 2 leading bail revocation cases where full SJC bench accepted appeals from the single justice and heard the cases on the merits without questioning single justice jurisdiction. In Comeso v. Commonwealth, the full bench upheld the jurisdiction of the single justice to review bail determinations under Section 58. The court stated, "We therefore uphold the jurisdiction of the single justice to review bail determination under Section 58. Similarly, we think the full court has jurisdiction to review, on exceptions, report on appeal, questions of law arising in a bail determination by a single justice under Section 58. That's Strannard v. Commonwealth and Commonwealth v. Baker. Gamaso, in addition to confirming such jurisdiction in the single justice session and the full court for question of law, the Comeso bench allowed de novo review of a bail determination in the single justice session. The statute is not explicit as to the role of the single justice. Relief in this type of case must be speedy if it is to be effective. Stack v. Boyle. Bail determination must often be done in haste without that full inquiry and consideration which the matter deserves. ID at 11, opinion by Jackson. We therefore think that the single justice has the power to consider the matter anew, taking into account facts newly presented, and to exercise his own judgment and discretion without remaining the matter for reconsideration by the Superior Court judge. Comeso Supra at 373. Thus, the single justice session is the proper forum and the framework for review is in place to satisfy the need for a speedy resolution for an incarcerated petitioner by allowing the single justice to decide the matter anew without remand under Comeso Supra. There is then the possibility of an appeal to the full bench on errors of law only. Applicable bail statute. Here, Ms. Fitzsimmons was wrongly surrendered in violation of GL Chapter 276, Sec. 58B. Section 58B limits the circumstances under which a trial court judge may surrender or revoke a 58A release of a detainee as follows. Section 58B. A person who has been released after a hearing pursuant to Section 42A, 58, 58A, or 87, and who has violated a condition of his release shall be subject to a revocation of release and an order of detention. Judicial officer shall enter an order of revocation and detention if, after a hearing, the judicial officer finds 1. That there was probable cause to believe that the person has committed a federal or state crime while on release, or clear and convincing evidence that the person has violated any other condition of release, and 2, the judicial officer finds that there are no conditions of release that will reasonably assure that the person will not pose a danger to the safety of any other person or the community, or the person is unlikely to abide by any conditions or combinations of conditions of release. So this is the parts they are relying on. There is no evidence that she broke any law. There are other alternatives to the ones she couldn't fulfill, and she is not a danger to society. And we don't have any answers for you. No one can give you that answer. It should be the law that anyone, especially in domestics and stuff like that, police, traffic stops, all of these things, for the officer's safety, wears a body cam. Because you just don't know what happens. I actually saw an officer was saved by his body camera because he was sued by a lady who claimed that he had racially disparaged her and I think racially profiled her while she was driving 110 in a 60 zone. No, he stopped you because you went 110 in a 60 zone. It wasn't because you had a certain color. Funny enough, his officer who came to help him when she absolutely lost her mind was also African American, and he was the one who took her down when she flipped her script. But still, better be safe than sorry where I can. It's the same with where they touch the back end of a car when they do a traffic stop, just so you have the DNA in case something bad happens and they go looking for the car. They have the DNA and they can say, oh, probably this guy who used it. Bold sections are relevant to instant appeal. By the plain words of the statute, order of revocation and detention are only permissible if there is clear and convincing evidence of a violation of release and there are no conditions of release that would assure the safety of any other person or the community, or the person is unlikely to comply with conditions of release. Here, the court's sua sponte imprisonment of Ms. Fitzsimmons runs afoul of the statute. Ms. Fitzsimmons did not violate a condition of release. She was there in good faith to avoid difficulty going forward. The Commonwealth, to its credit, recognized the situation as such and only wanted her to continue to be tested. When asked for its position or evidence, the prosecutor said no evidence to submit other than the argument that I talked about how the Commonwealth's belief is, in light of the court's releasing the defendant, that testing be done. There was no allegation of a violation or a request to hold a 58B hearing or any request to send her back to jail, just a request that testing continued. See recording of proceeding at 12/27/23, September 11, 2025, Essex Superior Court, McCarthy-Neyman, statement of James Gubitos, ADA, provided herewith as Exhibit 8. Nor did probation seek any hearing on revocation or allegation of non-compliance or notice of surrender. And this is the part that really chuffs my ass. I don't love the Commonwealth of Massachusetts. I have seen the Commonwealth of Massachusetts have a lot of agents who are less than stellar. Let's just say it that way. So if they really wanted her, they could go into court screaming, hey, she's not in compliance. We need her back in prison. They said, as long as she's still getting tested, we have no problem. And then the judge said, well, go back to prison. For what? Again, she has a problem. She asked the court, can we talk about my problem and fix it so I can be in compliance? The Commonwealth said, as long as she does the pee stick or the bracelet that tests your sweat, we're fine with it. We just need her tested. And the judge said, oh, go fuck yourself. Why is it this judge went absolutely rogue? That's the thing I don't understand. Doesn't Kelsey have a hearing today? I don't think she has a hearing. This was filed yesterday. Could be there's a hearing. I haven't heard anything about it. Scam tether would have worked fine without her having to blow. Yeah, if the bracelet that can detect, she could do a pee test. I think they even offered that they would drive her 10 minutes to a clinic and do the pee test. But again, who is it who wants her in prison? The judge, this is my big problem with this. The judge has nothing to do with this case. This has nothing to do with the judge. You have two parties that argue, and the judge's role is to be an impartial mediator. I know it's bullshit. I saw Judge Bev. But the judge should look at Exhibit A, Exhibit B, which one is more heavy on the scale of justice. Okay, we're going with Exhibit B. That's all the judge is there for. Why did this judge overrule the Commonwealth? Because if no one asks a judge to do something, why does the judge do it? That's not the role of a judge. A judge's role is to judge. Hey, I really want her back in prison. She's not in compliance. Hey, she doesn't want to comply because she needs to drink every day. Okay, yeah, I rule in favor of you. But here you come in and say, there's nothing in the B pile. Everything is in the A pile. She wants to comply. We are okay if she complies in another way. Well, B. This is what I don't understand. The judge I had in Massachusetts gave me a pee test for drugs and alcohol, and I didn't have a broken upper body and could breathe with no pain. Judge could have easily offered this. This is a choice crash. I'm 100%, and this is why I'm saying this is not a Karen Reed case. She did pull out a pew, and it'll be he said, she say. We don't know what happened. But why this extra layer of shit pulled on this poor woman? She lost her 5-month-old. My grandson is almost a year old. If you had taken him away from his mom when he was 5 months old, someone was going to get beat. You have that. She had 52 days in prison after being shot. She still have no connection to her son anymore. And you are as heartless, as shrew as you can be. You chuck her to prison with no one asking for it. I just don't understand it. Again, if the PO had come in and said, well, we can't do it any other way, if she can, it's either that or prison. Okay, then it's okay. How are we going to do this? I would say, well, she's on the GPS tracker, and can we make her pee three times a week or something like that? Or you could say, well, if she can't, if she doesn't want to do it, well, back to prison. Then we have to force her. But when everyone says it's okay, we're going to find another solution. Why are you over here? That's the thing I don't get. But again, go back and listen to what was stated. She was in compliance with all of it. She was in compliance with all of her testing. No one said she wasn't in compliance. She just came back to the court and says, I will be dizzy for 4 hours after blowing into this pipe. Can we find another way to test me that is not blowing? And they suggested 2 different other options. And the judge said, go fuck yourself. That's not how you do it. Yes, and she said, if we can't find it, I will keep blowing. But the judge still said, no, go to prison. You're out of here. To the contrary, Assistant Chief Probation Officer Jeff January fully supported an alternative testing means, but was completely shut down by the judge, who became increasingly angry that he was confirming and corroborating the defense motion with his own personal knowledge. He says, as recorded at C Exhibit 9, provided her in, my first job when we get an incomplete test is to gather more information, which is what we do. So, in response to the incomplete test we call ELMO, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long and hard as needed to complete the test. See ultimately at 4:20. She completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test. In conjunction to the hour and 20 minutes, we also know, and I observed it firsthand, that whatever the injuries are, and I don't know, and actually it doesn't really matter to me, when I was doing the installation process and observed what was generally in plain, court, any objection to any of the terms used by the probation officer? No? Okay. We have all of the information. We don't deem that non-compliant. She is attempting to take the test, and she ultimately passes the test at 4:20. So, with all of the information, that's not non-compliant. That's compliance with her obstacle. That's compliant with SCRAM testing. If she had missed the test, that would generate additional response from ELMO, and that would determine whether or not that was an actual non-compliance. This particular case, I don't deem non-compliance because she's complying with the scheduled program. I am aware of pain based on my observation from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliant. That's someone that, well, that's your position. That's non-compliant. It's really up to the court to determine whether someone is compliant or not with condition of release. It would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation notice from our end because there are many reasons for a test to be incomplete. The goal is to test to ensure that the person is sober, and we don't deem that non-compliance. We never have, and we never would in this case initiate a pre-trial violation proceeding based on an incomplete test that was subsequently passed. The schedule for her to be tested is something that we discuss. It wasn't ordered by the court. The court ordered for someone to be alcohol-free. What do you mean we discussed? So she knows when she's going to be tested. I discussed with Ms. Fitzsimmons, I discussed with the defense counsel about creating a testing schedule because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency. So again, the court has just said, stay sober. They haven't said you need to test at 2, 8, and 42 hour intervals. They just say, stay sober. And then the probation officer is the one who initiate how do we test it. But the judge was the one who decided that it has to be a blow test. It was random screens. Excuse me, Officer January. It was random screens. Now you're telling me she's on a schedule to get tested. Is that what you're telling me? We create a schedule, as we always do. Not in this particular case. We always do. It was random screens that was ordered. When we get an order and someone is placed on pre-trial condition that include remaining alcohol-free with SCRAM testing, we always default to creating a testing schedule up to 4 times a day. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the tests are coming. I want the test to be done randomly, with selected emphasis in bold. The court was incorrect and random testing was not ordered. There is no such order on the probation contract, and undersigned recalls no such order. See hearing recording. Whether random or scheduled, no loophole would have been created either way for undetected alcohol consumption. The court should have allowed an alternative testing method. The petitioner, Ms. Kelsey Fitzsimmons. Ms. Fitzsimmons is a lifelong North Shore resident with indelible. I don't know that. Oh shit, I didn't put it back up. What's this word? Indelible. I'm going to go with that. Indelible roots in the community from her upbringing, family, friends, job, and education. She went through the Methian public school system from kindergarten to senior year in high school. Once she graduated high school, she continued her education at Fisher College in Boston, majoring in criminal justice. She chose criminal justice with the goal of becoming a police officer, a career that is a lifelong calling for her. While studying criminal justice, she became the president of the Criminal Justice Club, where she was responsible for hosting many events on campus that pertained to important topics related to criminal justice, such as domestic violence, suicide awareness, fire safety, etc. She was inducted into the Criminal Justice Honors Society. Ms. Fitzsimmons held a position of 2 different jobs that pertained to her major. Through Fisher College Campus Police, she held a work-study position as a dorm proctor, where she was responsible for checking the IDs of everyone who entered the dorm building and ensuring that all students were following the dorm rules and regulation. She also obtained a job working security at Fenway. That's baseball. As security at Fenway, she interacted with fans and guests, had to be observant and proactive for any disruptive behavior occurring during games and concerts, and also screened and searched fans before they entered the park. Kelsey graduated college cum laude in May of 2020 during the peak of the vid. Unfortunately, her career plans were delayed as there were no police academies running during this time. She decided to continue her education and go to law school, and took night classes while working as a paralegal during the day. After completing her first year of law school, she realized it was not her passion. She then applied to the Essex County Sheriff Department, completed the academy, and was employed as a corrections officer there for over 2 years. In Kelsey's own words, working as a corrections officer taught me a lot and was a great stepping stone, but I knew my end goal was to become a police officer. I applied to the North Andover Police Department, went through the hiring process, and was accepted into the police academy. I successfully completed the academy while holding the position as treasurer of the academy. I then was sworn into the North Andover Police Department and successfully completed my required hours of field training. After a lot of hard work and a lot of years of gaining experience to get where I wanted to be, I finally had my dream job of being a police officer. I knew that there was no other job that would fulfill me like this one. Fitzsimmons was dedicating her life to two things: her law enforcement career and her baby. She has never harmed or threatened to harm her baby. Like countless new mothers, she has suffered from a transient bout of postpartum depression. She has been found by an expert clinician to be not dangerous and deserving of reunification immediately with her child. See report and CV of Dr. Paul Seisel, filed herewith at Exhibit 11. Any words on her house? Didn't the fiance file something to get the house as part of child support or something? I forget those details. No, he filed a lien on the house because he wanted the money to be secure for child support for the next 17 years. The way he figured it out, I don't understand. And I have some very smart mods. And I have Zach. No, he's not a mod. But he had taken, how was it? If she worked 40 hours every week, and you had the full amount, he asked for the full amount of money she would make on like minimum pay or something for the full year, which is not the amount you pay in child support. That's a percentage of that you normally. But he believed that he would be owed, I'm spitballing, $365,000, I believe it was. So to make sure that if anything happened and she sold her house, he put a lien on her house so he would get the money first. She has a house, I believe it's worth $500,000, but it's still owed 250, 350, something like that in the house. So he wants to take his money before she gets her money. That's what it is. A lot of people said when they saw it that he's forcing her to sell the house. That's not what it was. It was he put a lien so in case she sells the house, he would get paid first. He inputted the minimum wage on her, which is what's done when you're dead broke. Yeah, it was something like $13,000 or something like that. I can't remember. It was just when I saw it and I started doing the math on it, it was 100% if she worked every week, and normally you'll at least have a couple of weeks off. But it seemed really weird the way, because wouldn't he ask for a settlement on what his child support should be instead of having 100% of her income? That doesn't seem fair, does it? The father seems like a bastard, in my opinion. I read that motion that he filed. To me, it seems tailor-made to get what you want in court. You can do that if you have a good lawyer, especially in a custody case. Make sure that you talk to the lawyer first, and you will probably get it. Just we see this. It's the same if you have a DV case. The one who's the first one to call the police is right. We saw that in the Carolyn Tyler case, where the officer said, anyone who's through the door first, we believe. No, it was to make sure that she would have the money if she paid, if she sold her house, so he could put a lien on. I believe it was $365,000. He calculated, but that was if he got 100% of her minimum wage job, so she couldn't live. Seems like I don't know who made that, but that would have been, of course, yeah, taken out. He lives with his parents. Sister seems to always be around other than necessities. What else does he need? Well, school, doctor, clothes, maybe he doesn't do the he doesn't this is the thing I don't understand with American divorces, especially with rich and famous people, a lot of these NBA or NFL stars who get these crazy settlements where they have to pay like 250,000 to a spouse for 18 years. Well, they're not making the same money for 18 years they made that one good year they had in the NFL. Yeah, it doesn't matter. You just have to pay it. Well, then I go bankrupt. Well, F you. And why does this woman need to be kept in the standard that she had before? As long as in Denmark, we have a monthly fee that we pay. And I know exactly what it is because I can go in and I can look it up and say, okay, I'm going to pay 1,700 this month. Half of it tax deductible. Fine, fine. Then if you have a vastly different income disparity, she can say, well, I would like him to contribute a little bit more because he has all this money and I'm taking care of the kids, or the other way around, of course. And you can sue for that, but you will never get any of those crazy settlements you see like in Hollywood and sports, which I think is absolutely ridiculous. Jeff Bezos giving his wife $2.5 billion, or how much it was. You're thinking, okay, if she worked for it, but just for having a kid with someone, do you really owe them everything? That's weird. Yeah, I've seen NFLs there was an NFL guy, NFL no basketball guy had 11 kids, and they denied him to readjust it. Yeah, he's a firefighter, most likely. After the day of the incident, she was cleared to return to the work as a police officer. Her license to carry was restored. She's scheduled to be returning to work on July 4th. That day, on June 30th, her significant other and baby father betrayed her with lies and false allegations designed to take her baby from her and extract himself in the worst fate and cowardly fashion imaginable from their relationship. He told her to meet her at a local park and instead stood her and the baby up, and instead went and got an ex parte restraining order with an affidavit full of shocking lies. In no free society should a person be able to go to court, fill out a form, and send the police to a new mother's home and take a baby away from her without any opportunity to be heard. If there are allegations of imminent bodily harm, that is a matter of police and 911, not the court system listening to one side of the issue from a private party with their own agenda and ulterior motives, seeking a leg up on future custody matters. Use of the statute in such manners shocks the conscience and is beyond all norms in a nation of ordered liberty. It is time for SJC or legislative reform of this abuse of Chapter 209A. I totally agree. It's a different thing if the police gets news that you are a drug addict and we need to pick up your kid. But if I go in and tell the popo my ex-wife is absolutely cray, get me my kids, and they don't say, well, sure. What evidence do you have? Well, she said something the other day. Okay, we're going to go out and we're going to bring a person to talk to her. And that person is going to figure out, is it this bad? Seems really weird to me that you just go to the police and say, bitches be crazy. Yep, you have the baby. That, yeah. Did Bezos contest the amount? I don't know. Maybe she was He was glad to get rid of him. He traded her in for a younger model. Hey, Luna. I also heard that the test she was doing was not random enough for the judge. Yeah, we just read that part. I don't know what that is. Part of the reason celebrities end up paying so much is because the view is that the kids should have the same lifestyle regardless of which parent they are with. Yeah, but that's an American view. We don't have that in Denmark. But hey, we're socialist. We don't steal half your money and give it to your other spouse. You can just have that lifestyle when you're with your dad. Kelsey went home, and 3 male North Andover colleague police officers came to the house serving the other, taking the baby, her future marriage, and her career with them all at once, in the space of minutes, without her ever being heard or able to defend herself. She never pointed a pew-pew at any officer. Unfortunately, the department's decision to avoid body camera leaves the case as a he said, she said exercise and seriously affect the strength of Commonwealth's case, a highly relevant factor in bail determination. Kelsey was shot in her chest and has been hospitalized fighting for her life since June 30th. After the instant shooting endangering her life and resulting in the charges against her, Ms. Fitzsimmons has gone on record adamantly denying the allegation that she pointed a gun at a colleague and fellow law enforcement officer. See statement of Kelsey Fitzsimmons, Exhibit 7. She is and is presumed innocent. Nothing in this section shall be construed as modifying or limiting the presumption of innocence. She is also entitled to the presumption of personal recognizance. These immutable principles come together in this case to compel only one result: release on personal recognizance with a stay-away order. Factual errors by the court. Sorry. In seeking to defend the indefensible, the court resorted to attacking the attorneys on alleged procedural deficiencies and manipulation in its written rulings on the events on September 11, and in denying the reconsideration and ignoring the medical evidence it claimed was initially missing. The court apparently forgot that, at a prior hearing, the court suggested, and the defense agreed, that the facts in the prior filings would be incorporated by reference, so all facts could be before the court. In its ruling, the court apparently ignored this position, claiming a lack of medical evidence and a lack of specifics on simple urine testing that is ordered and or referenced in court likely every single day and undoubtedly utilized by this very court over her several years of experience. Way to stick it to her and calling her old. The record appendix contains everything filed for the trial's court's consideration and was, as far as undersigned counsel understood and expected, incorporated into the judge's state of knowledge on the bail determination as a whole. This is expecting 2 exhibits generated after the court's denials. The risk assessment prepared by Janet Tinley, LCSV, and the Hampton County Sheriff's Department incident report, both generated after the trial court decision. Nonetheless, these can be considered as part of the court's de novo determination. Thank you, Gravel Gertie. I should have my glasses on. For becoming a member. I think the judge already has an opinion on this one. Oh, yes. Yeah. They don't have them. That's what it says. At least they didn't have them on that day. Well, I am a baker, so of course it's muffin tops. Cops in my town doesn't wear body cams. I'm in Norfolk County, and yes, there were also granted them at the department in my town. No shock there. No, but they should. They really should. Just to see if I missed anything. Even former President Reagan was crazy about jelly beans. I'm not the biggest fan of jelly beans because I had some of them where they had those mixed tastes and I got some of the bad ones. I like a normal jelly bean. The court's focus on the state of the record was unexpected and inconsistent with the history of the proceedings. During the September 11 hearing for the motion for relief, the court incorrectly stated that it had no medical support, whereas defense counsel had submitted a medical notice to the court prior to petitioner's initial release on September 8th. See Exhibit 13. The medical notice laid out various issues Ms. Fitzsimmons was suffering with, including difficulty breathing, broken ribs, and other items provided in Exhibit 12, which was impounded at defense request. Further, Ms. Fitzsimmons being shot in the chest is laid out in the initial charging documents filed, and certainly no secret in the matter. The court was aware, as early as the second hearing on September 8th, that Ms. Fitzsimmons had difficulty breathing due to her healing punctured lung and broken ribs. See medical notice supra. Finally, the court has affidavits from the defendant and family, as well as 2 reports from a psychiatrist and a psychologist. In response to the court's revocation, claiming a deficiency in the medical documentation, defense counsel further provided the court with difficult-to-obtain letter directly from Ms. Fitzsimmons' very busy trauma surgeon, removing any issue whatsoever. And we have read this. This is the guy that says she still has fragments in her back. Dr. Parks corroborated petitioner's medical notice, her mother, and the ACPO, and opined, in my medical opinion, a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture vary, and it's difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movement such as deep breathing. Exhibit 14. The court ignored what it demanded in its denial of the reconsideration motion. The court also ignored the second to last sentence of Section 58B2, which provides the judicial officer may at any time amend the order to impose additional or different condition of release. Further, the court erred in citing 58A4 as the applicable circumstances and finding non-compliance. The court was using the wrong statute. This hearing was not a reopening of 58A. This was a court revoking release under 58B, which clearly, as set forth herein, did not conform to the requirements for such action. Further, the court misstates the record, alleging that defense counsel did not provide alternatives to SCRAM breathing. Urine testing is a common tool used by trial court every day and not a complicated and obscure request by petitioner. Counsel did, in fact, reference testing alternative at several times during its September 11 SCRAM hearing. See Exhibit 1, recording of hearing. 1, 2, 3, 4, 5, 6 times they mentioned it. Unfortunately, the court's demeanor severely curtailed any elaboration from probation or counsel, culminating in the court preventing any further discussion by walking off the bench mid-argument of undersigned. See Exhibit 15. Recording of Attorney Bradel's objection. The defense requested alternative testing, which was readily available and reserved specific for later to avoid future enraging the court, and the court, leaving mid-argument, prevented the remainder of the information coming out. The court violated the Americans with Disabilities Act. In finding that, after a thorough review of all arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged regardless of Fitzsimmons' claimed physical limitation. The court violated Title II of the Americans with Disabilities Act, prohibiting discrimination against people with disabilities in pretrial services without reasonable modifications. At the time the conditions was imposed, Ms. Fitzsimmons had recently sustained life-threatening injuries, including gunshot wounds to the right chest, hemothorax, with retained bullet fragments in the right upper back, moderate right hemothorax requiring chest tube placement, right middle and lower loop pulmonary contusions with active bleeding, grade 4 heptic trauma with active bleeding from the right heptic lobe, comminuted right posterior 12 rib fracture, and a right anterior 11th rib fracture at the costochondral junction. Sorry. Exhibit 13. Medical opinion of trauma surgeon Dr. Parks. He was clearly disabled under the ADA. The U.S. Department of Justice Civil Rights Division has directly addressed the ADA's applicability to this situation in its Information on Technical Assistance of the ADA Guidance Letter as follows. Title II of the Americans with Disabilities Act protects people with disabilities from discrimination in state and local government service programs and activities, including law enforcement agencies, justice system entities, and juvenile and adult correction agencies. The ADA requires criminal justice entities, including attorneys, courts, jails, juvenile justice entities, police, prison, prosecutors, and public defenders' attorneys, to avoid discriminating against people with disabilities. Entities must ensure that people with disabilities are treated equally in the criminal justice system and that they have equal opportunity to benefit from safe, inclusive communities. Non-discrimination requirements, such as the obligation to provide reasonable modification to policies, practices, and procedures, and the obligation to take appropriate steps to communicate effectively with people with disabilities, also support the goals of ensuring public safety, promoting public welfare, and avoiding unnecessary criminal justice involvement for people with disabilities. As a result of her gunshot wound, Ms. Fitzsimmons has severely diminished lung capacity and suffers acute pain when attempting to inhale or exhale deeply. Her treating physician has medically opined that a fracture of the 12th rib can cause pain that may persist for several months in the injury. I think this could be a problem, can cause pain. That doesn't mean it does cause pain. The severity and duration of pain following such a fracture vary, and it's difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movement such as deep breathing. Thus, an individual suffering from the condition in which Ms. Fitzsimmons has would make an individual medically incapable of blowing with sufficient force and duration to activate or register a reading on a SCRAM breathing device. Despite these limitations, a SCRAM device was installed on September 8th. Upon witnessing Ms. Fitzsimmons' inability to comply with the device's demand due to her medical condition, Assistant Chief Probation Officer Jeffrey January attempted to bring the matter right back to the attention of Judge McCarthy-Neyman, the preceding judge who had imposed the condition. However, Judge Neyman had already left the courthouse for the day and no immediate judicial relief was available. So even the probation officer said, hey, this doesn't work. On September 10th, Ms. Fitzsimmons, through counsel, filed a motion for immediate relief from SCRAM, which was met with Ms. Fitzsimmons' immediate incarceration by the court. On September 11th, immediately following the revocation, she filed a motion for reconsideration, which provided the email from probation and requested reasonable accommodations, see Exhibit 15, including an alternative alcohol monitoring method, e.g. random urine screen. Finally, on September 15, Ms. Fitzsimmons, through counsel, filed a supplemental filing on pending consideration, Exhibit 16, but the request for reconsideration was denied without a hearing. In doing so, the court explicitly referenced but ignored her physical limitation in the reconsideration denial opinion. The court revoked Ms. Fitzsimmons' bail and ordered her detained solely on the basis of her non-compliance with a physically impossible condition. Under Title II of the ADA, no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the service programs or activities of a public entity. The judiciary, including courts and probation departments, constitutes a public entity with the meaning of the statute and must comply with its mandates. A qualified individual with a disability is defined as someone who has a physical and mental impairment that substantially limits a major life activity and is eligible to receive public service or participate in public programs. Here, Ms. Fitzsimmons is a qualified individual with a disability due to her gunshot-related injuries, which substantially limit her ability to breathe and perform physical tasks. She was denied the full benefit of the pretrial release program solely because of her inability to perform a task incompatible with a medical condition, and was denied a reasonable modification alternative that would allow her to participate in alcohol monitoring on equal terms with non-disabled individuals. The failure to accommodate her disability and the punitive consequences of that failure through pretrial incarceration constitute a violation of her right under the ADA, easily remediable with available accommodation. There are numerous alternative alcohol monitoring options available, including transdermal SCRAM bracelets, non-breed based. Transdermal SCRAM bracelets, although not currently available in Massachusetts, is like a breathalyzer for the ankle. The SCRAM continuously alcohol monitor bracelet provides 24/7 transdermal alcohol testing for hardcore drunk drivers, high-risk alcohol and domestic violence caseloads by automatically sampling the wearer's perspiration every 30 minutes. The SCRAM bracelet eliminates testing gaps and encourages accountability. SCRAM not only supports sobriety but also results in higher compliance rate with court orders and increased community safety. See SCRAM Systems website. If it's not readily available, then could be a little bit of a problem. Random urinalysis testing and in-person probation check-in. Each of these is medically appropriate for the petitioner and serves the court's interest in monitoring substance use without violation, the ADA, or imposing impossible requirements. It is not too much to ask for the court to accommodate Ms. Fitzsimmons' conclusively demonstrated disability with an alternative testing method and not violate federal disability law to enforce a dubious procedural position. Errors of law. Finally, the court erred when it misstated the standard for using hearsay in a probation hearing. The court improbably stated in the hearing that the email from probation is not evidence. It's an email, it's hearsay, and this is an email from probation officer. The court gives that zero weight. Exhibit 17, Mark 1210. The court's determination on an email from Assistant Chief Probation Officer Jeffrey January as hearsay and not evidence is an error of law, as the rules concerning admissibility of evidence in criminal trials shall not apply to the presentation or consideration of information at the hearing, and the judge shall consider hearsay contained in a police report or the statement of an alleged victim or witness. In its September 16th decision, the court asserted that hearsay must be reliable and there must be good cause for the decision not to present live testimony. Commonwealth v. Abbott. In doing so, the court failed to acknowledge the abandonment of good cause requirement as stated in Commonwealth v. Henderson, which states ordinarily the revocation judge should excuse the witness originating the hearsay information only for good cause. However, if the hearsay information satisfied the standard of substantial reliability or trustworthiness, the need to show good cause disappeared. Accordingly, the court was applying a legal faulty standard to the evidence presented by the defense and should have fully credited his contemporaneous documentation of Ms. Fitzsimmons' discussion. Conclusion. The court clearly dispenses of the safeguard that bail be revoked only after finding that there is no combination of conditions that would allow the defendant's release, which furthers the bail statute's purpose of establishing the right of accused in most circumstances to be admitted to bail. There are ample alternatives to incarceration for Ms. Fitzsimmons, which were for some reason assiduously avoided by the trial court. For the foregoing reasons, Ms. Fitzsimmons respectfully requests that the single justice hear the matter regarding her bail revocation, vacate the ruling of Superior Court revoking bail, and return her to liberty by granting personal recognizance with a stay order or such other conditions under Section 57 or 87 of the bail statute or such 58A orders as the single justice deems necessary. Finally, she requests that the justice enter any further orders and ruling necessary to effectuate her request and any such other relief as the justice deemed proper. Wherefore, Ms. Fitzsimmons respectfully requests the single justice enter appropriated orders as above. Filed yesterday. Whew, that was a long 23 pages. All in all, to say the judge didn't have the right to do it, the judge was wrong in her basis to do it, and the judge didn't look at the evidence, even though they were totally in compliance with the law and good practices. This is, hey, Wrestler. This is scary, to be honest, that of course, don't go waving no pew-pew near an officer. I'll say it over and over and over again. This could spell some trouble for her. But at the same time, why is this judge acting like such a canoe de douche? I really don't get what is her problem. Why is she so hell-bent on setting Kelsey back into prison? That's the thing I don't understand. They have the medical doctor. She claims it's hearsay from the probation officer. She's an officer of the court. Why don't you trust his emails? I really don't see. Basically, what will happen is the judge will be irritated and will continue to deny everything, even if it makes sense to allow. No, because this is at a different level. They are going above the judge to have a new ruling, and further ruling should be done by another judge because they believe this judge isn't following the rule. That's the thing. The problem with the SJC is that they are buddies with the lower court judges. That's why Karen kept failing there, covering the back of corrupt Canoni. Well, Karen's issues were way different than these ones. And most of the motions they filed, I don't believe that anyone was really believing that it was going to work. But this is something different. She didn't look at the evidence. She claims that she couldn't look at some of the evidence because it was hearsay, even though there's no hearsay rule regarding this. So, to me, listening to her, reading the piece of paper that took away Kelsey's baby, she seemed like an angry old woman who had some kind of stick up her butt. Why, I don't know. She seemed highly emotional, highly disrespectful, and very, very partisan against Kelly Fitzsimmons. That's the problem. What makes me believe, I didn't say that. I said she did brandish a weapon. I don't know what she did. I don't know. I have her word that she didn't. I have his word he did. I wasn't there. But what I do know is she had a pistol. That's all I can say. I wasn't there. No one can tell me if she did or she didn't. Because so far we have he said, she say, and he said, she say is really, 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 really good evidence. They ask for a new judge in the beginning. If you came in a little bit late, they are asking for it in the beginning of the motion. They want a new judge. Also, the judge operated outside of the point of the hearing. The judge just took everything and threw it out the window and said, go F yourself. President, I don't care about that. The rules, I don't care about that. Best practice, I don't care about that. Listening to alternatives, I don't care about that. Listening to my own court officers, the probation officer who works for me and says, we can figure something out. Nope, I'm just going to lose my mind and start screaming. That's, well, standing up and walking out mid-argument to me seems emotional. That's not what a reasonable judge does. This judge doesn't like Bradel because of Turtle Boy. I don't know if that's true. I don't know this judge, and I haven't. The funny thing is, with Judge Bev, we heard all of these things about the Cape House and all of that. I don't know if this could be. I don't know. This could be an outcome of Bradel having the Turtle Boy taint on him. That the judges have just decided, well, kind of like all the aunties believe that anyone Alan Jackson will now work for in the future are all absolutely guilty. I don't know. But that would also be an irrational thought to have, that because he represents, and that's why I said the judge is the neutral party in the middle who looks at Bradel and looks at the Commonwealth and say, who has the best argument? She knows that Bradel has probably at some point had a kitty diddler that he was a defense attorney for. If he does those type of cases, he potentially had someone who super clearly unalived his wife by, I don't know, because the thing about defense lawyers, they have a lot of guilty customers. But that doesn't mean that this defense lawyer shouldn't be treated exactly like every other lawyer. Just because he represents people who are in a bad place. That's why I'm so mad when everyone comes in and, shut up. They don't need a defense. He's guilty. Well, he does need a defense. And everyone has the right to a defense. And just because Bradel might have had someone as a client you don't like, you don't use it against his other clients. That's not how a judge should act. That's highly irrational for a judge to act in that way. Well, apparently the department has them, but they didn't choose to take them on. The scale was just one way only. But don't understand the scale either. What? Well, of course they hang with the same people they hang with. Actually, hey, people who might be new, a lot of new people probably drop by here today. I do jury duty in Denmark. We do it differently. We do it 4 years at a time. I've been doing it for a lot of years. And the first year I was there, the judges actually had a Christmas dinner with the local defense lawyers and the prosecution. They had to say no to that to make sure that there was impartiality that could be guaranteed, even though there was no over or under compared to other courts in Denmark. But just to make sure no one could blame them for anything, they don't have that dinner anymore. They don't receive anything if there's a party or anything. No one gives anything from a defense lawyer to a judge at his 60th birthday or whatever it could be, anniversary, whatever, because they have to clearly delineate between the sides. And it's the same with the prosecution. I hear judges yell more at prosecutors than I hear them yell at defense attorneys, because you have the money, you have the power, you have the evidence. Be prepared. Sadly, not a lot of them are that prepared. Hey, Mary. But that was it I think I'm gonna jump off. We hope there will be some resolution to this fast. Sadly, justice moves slow. I'll be having the wonderful Emily C on in about an hour. I think you should come back because we're gonna put our shoulders down. It's Friday. We had a rough week, all of us. We don't need more of this. So we're gonna have a and get to meet Emily C. She's just started her YouTube journey, and if you don't know who she is the one with the wonderful skits about Hank Brennan and Lally and a million others. But she's also a newly started YouTuber who she's just a sweetheart, and I think you should come back and watch me and her talk a little bit about her journey into YouTubing. And let's just take it down a notch. It's Friday. Calmale, everyone. Come back in about an hour and enjoy a little chitty chat about nothing, because sometimes we just need to cleanse the palate.